Great. Good afternoon, everyone. My name is Michael Peterson, and I'm an employee relations consultant in human resources. And my job is to help the employees when they have claims of discrimination, harassment, or retaliation, and also to educate people on their rights here at Sully County and to guide and direct in those policies. So the purpose and intent of today's presentation is to give you knowledge and a basic understanding of your employee rights during and after pregnancy, and also how to navigate the different things that are available to you, and also give you the information as to who you can contact for questions. Just to note, we are recording this session, so go ahead and put your questions in the chat, and we will answer those questions at the end, because we may answer the question you have during the course of our presentation, but we will take questions at the end. So as an employee relations team, we are responsible for the county level. If someone has a complaint that takes them further, they might make a discrimination claim to what's called the UALD, which is the Utah Anti-Discrimination and Labor Division. And then governing all of this is what's called the EEOC, or the Equal Opportunity Commission, and they're on the federal level. And what happens is they take a lot of complaints about discrimination, harassment, and retaliation and litigate them. So we thought it might be interesting to just give you an idea of how seriously employers should be taking rights of those during pregnancy. And so we'll go through just a couple of case studies. If you ever want an interesting read, you can go to the EEOC.org website to read about different cases that they litigate and try to come to a resolution between employer and employee. So our first example is about White Pine Senior Living. Now this is located in Minnesota. It's a senior living facility, and they awarded a promotion to a female employee, but once the manager learned of the employee's pregnancy, the manager threatened to demote her and launched a campaign of excessive and heightened scrutiny of her work. The employee opposed the discrimination and filed the discrimination charge with the EEOC, causing the manager to retaliate through negative performance reviews that threaten employee-related harm. White Pine Senior Living finally forced the employee to quit by insisting that it must hire a replacement for her, because they assumed that the pregnant employee just would not be reliable during her pregnancy. Now this, of course, violates Title VII of the Civil Rights Act of 1964. Now that prohibits employers from discriminating against employees on the basis of sex, which includes pregnancy. So how did this get resolved? The employer was ordered to pay $73,000 in lost wages and other monetary relief to the employee, as well as they ordered them to revise their internal policies so that they could prevent further discrimination in this area. So a pretty serious charge and a pretty serious fine to the company. Our next case that the EEOC looked at was, it involved a pregnant worker who had been employed by Kurt Blumel Incorporated, and that was a plant nursery in Baldwin, Maryland. This employee requested maternity leave in September of 2023 with the expectation that she would return to work after giving birth. So when she attempted to return to work in December of 2023, she was told that no work was available. However, the employer had hired new non-pregnant employees before and after her attempted return. So this alleged conduct violated the Pregnancy Workers Fairness Act, which is brand new. And it also violated Title VII of the Civil Rights Act of 1964. We're going to get into those acts in just a few minutes. And this employer was ordered to pay the employee $40,000 and also change their internal policies and make them aware that these things should be taken seriously. So the discrimination of women who are pregnant often arises from stereotypes and assumptions about their job capabilities and commitment to the job. For example, An employer may refuse to hire a pregnant worker based on an assumption that she will have attendance problems or leave her job after the child is born. So, employment decisions based on such stereotypes or assumptions violate the Pregnancy Discrimination Act of 1978, which amended the Title VII of the Civil Rights Act. We also have new legislation that we will go into that further emphasizes and reinforces the rights of women during pregnancy and after pregnancy. So Passion Wales, our employee relations manager, will further explain these laws as well as the policies that we have here at Salt Lake County.
Thanks, Michaeline. And as Michaeline just mentioned, these rights are not just feel goods or recommendations. These rights are actually rooted in legislation or laws, and particularly what we call in a collective employment laws. So as Michaeline mentioned, one of the first employment laws that existed for pregnancy workers is the Pregnancy Discrimination Act of 1978, which did amend rights under the Title VII Civil Rights Act. And essentially what this did is it cleared up not just a gender discrimination, but specifically for those workers who were pregnant or pregnant or experiencing complications through pregnancy. And it really focused on ensuring that they weren't treated differently in aspects of employment, which included the hiring, firing, pay discrimination, job assignments. And so that perception of you're pregnant, you won't be able to do that job became protected in 1978. It also ensured that other things like benefits and leave insurance were also treated fairly. In addition to the Pregnancy Discrimination Act, the Americans with Disability Act also plays a role in a pregnancy workers' rights, which is the Americans with Disability Act was created in 1990, and it is a law that prohibits discrimination in employment. It also focuses on public spaces, local government, so state and local government. It has reaches to transportation and how we communicate with others, but ultimately it ensures that individuals with disabilities have the same or equal opportunities in all aspects of their life, which also, as mentioned, includes employment. And so the ADA does require employers to provide a reasonable accommodation if an employee has a disability. And while pregnancy on its own merit is not considered a disability, many of you are probably aware that pregnancy may cause or contribute to other types of disability, such as preeclampsia, gestational diabetes, iron deficiency anemia. And so it supports, if you will, the Pregnancy Discrimination Act, as well as some other things we'll talk about in just another slide. But it is important to know that pregnancy itself is not the disability, but the effects of pregnancy could contribute to other types of disabilities. And now here we are in 2024, I guess technically, when the Pregnancy Workers Fairness Act, also known as PWFA, was implemented. This originally started as an act or legislation in 2023, and in 2024 it was confirmed, and also became a law that the EEOC has and will be enforcing going forward. So we think it's so important, not just for the employees to know what's new, but also how that impacts and supports those other two laws. So the Pregnant Workers Fairness Act, or PWFA, requires us to engage in a reasonable accommodation. But unlike the ADA, it does see that pregnancy is the cause for the accommodation. So simply being pregnant or having any medical moment that arises out of the pregnancy or limitations due to the pregnancy, including childbirth or any related medical conditions, would cover an individual. Also, unlike the ADA, there's not an extensive requirement for paperwork or medical intervention, such as being pregnant is considered a known limitation. You can see that the individual is pregnant in some cases, and even if you can't see it, by the employee simply disclosing that they are pregnant and they are experiencing limitations due to pregnancy, we are now required to engage in what would be considered an interactive process or conversation to understand what the employee needs. So we are a covered employer if that helps also say, you know, there are some entities that are not covered, but the Salt Lake County is a covered employer and we are required to engage. So as a covered employer, we can't fail to make these types of accommodations. We can't say the workload is too much to burden. We can't force pregnant workers, like the example in the case study, to leave their position or switch their position, or we can't engage in any type of conversation that would persuade the pregnant worker to leave on their own for fear of getting fired. So there's lots of rules around this. And while we're giving you just a quick snapshot, please know that there's additional information and tools that we can provide to you. But we also thought you may have some questions. So far, I don't see any questions in the chat, but we created a couple of frequently asked questions to help you understand which of these laws may apply and what happens if you ever feel that you need to reach out or have questions. Our first question: what if I'm having difficulty doing my job because of pregnancy or a medical condition related to my pregnancy? So as mentioned, you may be able to receive an accommodation under the PWFA, and examples of accommodations would be extending your breaks or an altered break schedule. That would still be a non-paid break, but maybe you need to take a break every 2 or 3 hours versus 1 to 4 hours or 1 every 4 hours like policy kind of outlines. Maybe permission to stand at your desk or permission to sit at your desk. Maybe an ergonomic office assessment needs to be conducted so we ensure that we have the proper chairs, monitors, the monitors are the appropriate height, and it could even include shift changes. As we know, probably one of the most common limitations to pregnancy is morning sickness. Many employees or many pregnant workers experience morning sickness. And so if that is a limitation that you're experiencing, you may say, for this temporary being, I'd like to request a shift change so that I can be at home when those symptoms onset. And all of these are discussion points. Just like under the ADA, the request is made, the agency and the employee are required to engage in the interactive process to decide what is reasonable and what accommodations can we put in place. Also of note, you may still qualify for an accommodation under the ADA if you have a disability that is caused by the pregnancy, such as those examples that I provided previously: preeclampsia, anemia, swelling of the legs. I'm not sure, I guess hypertension or any of those other things. Another question you may have is, what should I do if I need an accommodation, light duty, or leave because of my pregnancy? So first, we ask, start by communicating. Start by engaging that conversation first with your direct supervisor. If you have an HR professional in your agency, that's a great place to start. And you can always reach out to us to start those conversations. Because there's no requirement for paperwork or form, it's simply a written request of what do you need and what are you experiencing right now. As we know, pregnancy can evolve over time. And so we say right now, because in your first trimester, you may have different needs than what you may need in your second or even third trimester. And so you start by submitting the written request. You should inform your supervisor, what are the pregnancy-related concerns that you're having, and what are the pregnancy-related, limitations that you may be experiencing in doing your job, such as, due to the swelling in my legs due to the preeclampsia or the hypertension, I'm having difficulty standing at work, and I'd like to get permission to bring a chair to my work environment or my work stand if I typically would stand, or the chair that I have is causing additional back pain and it makes it uncomfortable for me to sit for long periods of time. I'm requesting either a different chair or a different rotation. Also of note, you cannot be terminated or refused, promotion or anything because you've asked for an accommodation. That is considered a protected activity, engaging in a protected activity, and you would be protected not just from the large moments of termination or promotion, but also any form of retaliation, even being excused from projects or things that you're currently working on. It's also important to note that even the accommodation, whether it's under the PWFA or the ADA, it does not excuse poor performance or poor behavior. As an employee, you would still be expected to do the essential functions of your job and meet the expectations with this agent or with this accommodation. So with or without the accommodation, you would still be expected to do those things. So what if there's no way that I can do my regular job even with an accommodation? So first, we would ask you to engage that conversation with your healthcare provider. As we mentioned, PWFA is a newer law, and so some healthcare providers may not be operating with that level of detail or knowledge and or the awareness of your job, such as they may say, we would recommend you not working. We would ask that you engage in conversations with your healthcare provider to ensure that they understand what you do and they understand that maybe an accommodation could exist. But if you and your medical provider determine that an accommodation does not exist, then you may have rights to take consecutive leave through duration of your pregnancy. The leave can be assumed under PWFA, the ADA, and even FMLA if you are eligible. And unlike FMLA, there's no eligibility requirement under PWFA or ADA, as long as you are an applicant or even an existing employee or any function that does business with the county, such as a time limited or a temp or any of those employment relationships, you would be covered. Still seeing no questions, so I'll continue to move on. If my employer knows that I am pregnant or may become pregnant, could I get fired? I think we know the answer to this one. And the answer is based on the pregnancy, no. But yes, if you are a pregnant worker and you have not met the expectations and it is rooted in something that is performance-based or a policy violation, you could get fired. But for the sake of this conversation, we are going to assume that the getting fired was on the basis of being pregnant or may become pregnant. And under the Pregnancy Discrimination Act, that is not allowed. That would be a form of discrimination. And we would encourage you to reach out to our agency so that we can help you navigate through what that process looks like if you needed to file a formal complaint or just have those questions. And so, no, you can't be fired if you are pregnant, you were pregnant, if you're going to become pregnant, or if you're perceived to become pregnant. What if I'm being harassed because of pregnancy or a pregnancy-related medical condition? So harassment based on pregnancy is a protected class, and it would be something that would be covered. And if you feel that you are being harassed because of your pregnancy, we would ask that you report it immediately to your supervisor or any other leadership you have in your agency, such as an HR professional, and report it to our office so that we can investigate the matter on your behalf. As mentioned, the Civil Rights Act of 1964, Title VII of the Civil Rights Act, specifically prohibits discrimination based on multiple things, but including pregnancy as amended by the Pregnancy Act of 1978, as well as supported by PWFA. What should I do if I think my rights have been violated? Again, reach out to us. While we hope that we have educated and trained our managers to not engage in these things, the violation could also be supported through a coworker or a peer. And so if you believe that any of these rights have been violated, or if you are just unsure of what those rights are, please reach out to us. We're happy to have the conversation, as we've only answered 10 or so questions, and we know that there may be many, many more. So it could be grounds to file an EEO complaint. It could be just a conversation that you have with us to better understand what your rights are. And it also could result in a training moment. We are all still navigating these very new nuances of these laws or the amendments to these laws. And so sometimes it's I didn't realize that that was a new expectation of me. And now that I'm aware, I'm happy to oblige. So let's talk about some other things that are available to you here at the county. So beyond your rights, parental leave is a great benefit that the county offers, and it is available to those individuals or employees who qualify. So you must be employed for 12 months or 52 weeks. You must have worked 1,250 hours, and you must be taking the lead for the birth of the child or the placement of a child in adoption. Foster care does not qualify for a parental leave. So if you meet the eligibility requirements, you may be eligible for up to 12 weeks of paid leave. And the reason it's up to 12 weeks is because as the birth parent, you receive 6 weeks of leave for the effects of giving birth, and then you receive additional 6 weeks of leave for, bonding and care. The non-birth parent does not receive 6 weeks for the effects of giving birth. Rather, they simply receive 6 weeks of, providing care to the child. And so depending if you're the non-birth parent or the birth parent, you may be eligible for a different amount of leave. This is considered paid leave, and it does run concurrently with FMLA. So that if you are eligible for FMLA, you would use your FMLA, which is your job protected leave, and then you would use parental leave for your pay, much like if you were going on vacation and you wanted to get paid for that time off. So you're out on leave, and now it's time to return to work. We hope that the return to work is as seamless as the moment when you left. But we also know when you're returning to work, the child may still be an infant. And so it is important to know that you still have protections even after the birth of your child. In fact, you have up to 1 year after the birth of your child to engage in breastfeeding or expressing milk. This is under the PUMP Act of 2002. The PUMP Act was actually one of the newer laws. It's now about 20 years old, I guess, but one of the newer laws that gave also clarity to returning mothers into the workplace to ensure that they were provided not just the opportunity to breastfeed or express milk, but also a space and other accommodations to ensure that that moment is protected as well as comfortable as possible. The Employee Wellness team has been working on a list of locations, sites, and rooms, so that if you are in an agency and you're not familiar with where your mother's room, is what we typically call them, is located, please reach out to the Employee Relations team or the Employee Wellness team so that you can gather additional information. They have created not just a great packet that I'll refer to and put the link in the chat towards the end, but they're also working to ensure that those mothers' rooms are nice and what we would call comfortable, to ensure they have a chair and a refrigerator, which is also supported by the PUMP Act, a requirement as an employer that we would have those things for you guys. But also going back to what are your rights when you return. So you would have the right to, just like before, request additional breaks or extended breaks. And those breaks are unpaid, but you wouldn't be held accountable for that. That wouldn't be considered a negative thing. It would be protected. And prior to returning to work, you should ensure that you have notified the benefits team of your new addition to your family. This is considered a qualifying life event, and under our current policies for benefits, you have 31 days to report that. And we know that this is such a life-changing moment after giving birth to an individual. It's life is changing, but it is important to ensure that you report that birth so that your child can be covered under the benefits. We would hate for you to miss that deadline and then have to wait sometimes months until open enrollment. The benefits team can definitely provide you additional information, but essentially their request is upon becoming aware that you are expecting, a call to the benefits team would be great. When you leave on maternity leave or parental leave, notifying that there's a pending birth. And then, of course, at the time of the birth, shortly after, typically after you have the birth certificate or confirmation of birth, you would reach out to them and report the qualifying life event. There's some paperwork involved, but ultimately they will walk you through this process and try to make it as seamless as possible as soon as they become aware of your QLE. So in those cases where the pregnancy does not result in a live birth, such as a miscarriage or even a stillbirth, the county does provide bereavement leave, and bereavement leave is a separate moment from just funeral leave. While it runs concurrently and it's a part of the funeral leave, it's specific to stillbirth or miscarriages. Bereavement leave is up to 3 work days of paid leave once the employee has experienced a miscarriage and or had a stillbirth. This policy is particularly covered under policy 4-200 section D, and it was an amendment due to some state legislation a few years ago. So if you're not familiar with that, we would ask that you just go back and read through it. We've referenced a lot of policies and laws today. So we put this slide here so that you can at any time refer back to these very important policies. HR Policy 3-100 talks about the workplace harassment, discrimination, and or retaliation on the basis of pregnancy or being pregnant. HR Policy 3-200 talks about reasonable accommodations under the ADA. HR Policy 4-200 talks about leave practices such as bereavement leave and or parental leave. HR Policy 4-300, insurance and retirement programs, talks about the qualifying life events and how you are to report that. How do you add, your child or even a new husband or any type of qualifying life events beyond just the birth of a child. And then lastly, HR Policy 4-600, FMLA or family and medical leave, talks about the rights under that policy, as most employees who are going on leave will qualify for FMLA or should use FMLA to protect their job while they're out on leave. All of these policies are located on the HR website. And now it's time for questions. I do see that there were a few questions posted in the chat, so thank you for that. And I'll just, oh, I am so sorry, I hit the wrong button. I will go to those questions. Michaeline, would it be easier if you read through those?
Sure, I can do that. Brittany asks, are there any protections that are in place postpartum as well, or are all of these specifically covering the duration of being pregnant?
Okay. Thanks, Brittany, for that question. And as we just chatted, the PUMP Act does cover postpartum. That's probably the closest thing. The Pregnancy Discrimination Act also covers anyone who's recently given birth. As we disclosed that for the most part, those protections exist for up to about a year after the birth of a child, which is after returning to work. If you are being treated differently because you gave birth, then you would want to still reach out to us.
Okay, and Brittany also asked, in previous years, there was a rule that if you and your spouse work for the county and you are going on maternity leave, the non-birth parent couldn't take leave. Is that still the case?
No, because I'm not sure exactly what you're referring to, but the closest thing that comes to mind is the shared time off under FMLA. FMLA has a rule beyond the county that says if 2 individuals work for the same employer, the allotment of FMLA, so the total of 12 weeks, is shared. That may be what you're referring to, but here at the county, FMLA is shared while parental leave is not. And so the birth mother could receive the 12 weeks of parental leave, while the non-birth parent would still be eligible for up to 6 weeks. So they could take time off. In fact, we've designed the parental leave so that the non-birth parent has 6 months to initiate their leave from the qualifying event, whereas the birth mother has to initiate their leave at the time of birth. So we've even expanded that window to try to accommodate for those families that work for Salt Lake County.
Martisha asks, so since we'd have to be working here for a year to get parental leave, what would be the case for high-risk pregnancies if something led to preterm labor before working here for a full year?
It's a great question. And this is it depends. This is when we want you to reach out to your supervisor and our team so that we can discuss what's going on and determine, would the ADA potentially step in to cover? Would the PWFA step in to cover? And under Both the ADA and PWFA leave is considered a reasonable accommodation. So even if an employee is not eligible for FMLA or parental leave, they may request time away from work under the ADA or PWFA. We determine what's reasonable by the length of time the person needs to be out and other circumstances or factors. And so this is always a moment to ask so that we can see what, if any, of these things would apply to that situation. Okay.
All the questions in the chat right now.
Well, I will definitely leave our contact information on the slide. And I did want to, I guess, reference or plug, so I'll put this in the chat, that the Employee Wellness Team has an amazing website, Maternal and Parental Health. It has some tools that you can refer to, and specifically the resource packet. They have a comprehensive resource packet. We've worked with them to try to identify, and if you click on the link for the packet, that's where you will find additional information on mother's room locations, what to do, and many of the things that we've covered today, but kind of expanded. What are your rights and what should you expect during pregnancy, after pregnancy, and beyond? So if there's no further questions, turn it back over to Brittany.
Thank you guys so much. We really appreciated this information. I know I had a couple of questions and you provided perfect clarification for that, so I really appreciate it. And I love the encouragement that you've provided today to just start the conversation, right? I think if you're hesitant or nervous about this, even if you don't find yourself in a situation needing to take leave, but you want to ask questions, I think that it's perfect encouragement that you provided today to reach out to your team, reach out to your supervisor, and just ask questions, right? I love that it's, again, knowledge can be power, and understanding your rights is super important, especially if it's applicable to you now or sometime in the future. So thank you guys so much. We really appreciate having such a wonderful employee relations team here at the county. And if you haven't spoken with this team before, I highly suggest that you do. You'll be met with kindness and understanding, and definitely helping you answer those questions that you have. So again, thank you guys so much. I really appreciate that time that you've spent with us today. And this recording, like mentioned earlier, it is recorded, so it will be up on our employee wellness website along with our YouTube channel, and the link that Passion provided to you, the recording will also be there as well. So it will be all in one place ready for you to go. And if you're here attending this as a supervisor and you wanted to provide education to your employees, maybe they've been asking questions, this is a great place to refer them to as well, as you can refer to it to be able to learn a little bit more for yourself as well. Thank you guys so much. Really appreciate your time. It's been wonderful. And we hope to speak with you soon.
Thank you.